Thank you for visiting the Combs Waterkotte website and our Orders of Protection Defense Lawyer in Missouri website page. Regardless of the crime, we believe everyone is entitled to the best possible legal defense in the state of Missouri. We have created this audio version of our website page to help you better understand our services and protect your future, freedom, and reputation. If you have been served with an Orders of Protection in the state of Missouri, we can help. Don't face the state and court system alone during your Order of Protection. Contact one of our Missouri Orders of Protection defense lawyers today at 314-900-HELP to protect your rights and future. Combs Waterkotte is committed to handling all Orders of Protection defense cases with confidential care and understanding. We are not here to judge you. We believe that everyone in Missouri, regardless of the crime they have been charged with, deserves an aggressive legal defense and to have their legal rights protected. With that being said, let's discuss hiring our Orders of Protection defense lawyers in Missouri and setting up a free consultation with our attorneys. Orders of Protection lawyers in Missouri. Defense attorneys here to help. We understand that there are two sides to every story. If you were served with an Order of Protection in St. Louis or anywhere in Missouri, call Combs Waterkotte to protect your interests. Defending against an Order of Protection in Missouri. In Missouri, an Order of Protection prohibits anyone who has been served to contact the alleged victim. This includes communicating, threatening, abusing, or engaging in any way with the order's petitioner. This is also known as an ex parte, or Order of Protection, or more commonly known as a restraint order. We handle cases like your every day. Reach out to our St. Louis Orders of Protection lawyers now at 314-900-HELP. Orders of protection are usually attached to domestic violence and to safeguard any alleged victims from further violence, both physical and emotional. Ex parte Order of Protection typically involves temporary restraining orders. This may mean that the accused party cannot return to a certain property, communicate with spouses or children, or come near the petitioner until the court, police, and lawyers become involved in the case. A full Order of Protection can only be issued after a hearing on record when the notice has been served and the respondent responds. Both Orders of Protection can be suspended by a judge or renewed for a longer period of time given the circumstances. An Order of Protection can be filed and served if someone alleges that they have experienced abuse, harassment, physical harm, stalking, or some other type of dangerous behavior. There are various rules based on where you are located and where the case took place. In St. Louis, for example, you have to reside in the actual city or county and be served by the local court or a police officer. Common reasons for Orders of Protection in Missouri. Commonly known as a restraining order, the petitioner, alleged victim of some criminal act, will have to file with the court. Common instances of this may involve domestic violence, sexual encounters, emotional abuse, theft, and other crimes. You can learn more about county courts and how to file an Order of Protection here. It's important to note that minors are also able to file restraining orders against adults. See below for common allegations that may lead to an Order of Protection. Common reasons for restraining orders in Missouri. Stalking, sexual assault, harassment, domestic violence, marital asset disputes, and property destruction. Being served with an Order of Protection in Missouri. If you are the one being served, it will be so in person to ensure you receive the proper documentation. There are various ways this can happen, but when it does, the respondent should read the documentation and contact a criminal defense attorney as soon as possible. You can also call us here, 314-900-HELP. What dictates an Order of Protection? The laws behind restraining orders are vague for a reason. Whether or not the order of protection is approved, there are a few things a judge will look at. Substantial evidence. The respondent's history of violence. Threats, physical and digital. Case history. Neglect to respond. It's also important for anyone filing an order of protection to abide by rules. For example, don't text, call, or communicate with the defendant under any circumstances unless the court or your criminal defense lawyer says it's okay to do so. Usually, this would be for coordinating childcare or other unique circumstances. Criminal defense attorneys in St. Louis. If you or a loved one are looking for guidance about an order of protection or a restraining order, don't wait to contact our firm now. Combs Waterkotte is recognized as a leader in criminal defense throughout Missouri.